second here. I've been with a financial services company working in their corporate human resources office for 15 and a half years. So I did a lot around corporate HR, from recruiting all the way through employee relations. And last, before I left the corporate world, it's been working with the strategic business partners and being able to help with the leadership teams in terms of meeting their human capital goals and things of that nature. So that's what brought me and drove me to wanting to provide information around HR specifically to small business. The small businesses out there do not have an HR department that can support them. So really quickly, can everyone see my screen or not yet in terms of the sharing of my presentation?
Not yet.
I can see it.
Let's see here. You see the entire presentation?
Oh, no, I just see you.
No, you just see me right now. Okay, give me 1 second here. And I think I was telling Crystal here earlier that I'm new to Teams. I'm very much used to using Zoom. And so this is my first time trying to get this going. So give me a minute again here. Apologies for the technical difficulties.
If you need to share the whole screen, that works as well.
And I might have to do that. So give me a minute. Yeah, because earlier I was able to just show my presentation. So all right, so great, thank you. This is now my entire screen. Okay, so thank you again for joining us with the HR Essentials and 2023 Labor Laws for Small Businesses. Now, since I cannot see the chat at the moment, I will stop in between sections so that I can at least see any questions that are coming out of the chat, or at least pause for any of you in regards to some specific questions that you may have regarding a particular topic. Full disclaimer, of course, this is going to be a presentation that is specifically for educational and informational purposes. Please do not utilize any of this information as legal or financial services advice. So you definitely would want to consult with a lawyer, small business lawyer, or tax or financial advisors in regards to anything pertaining to any money matters, and of course, legal decisions that you want to make for your business. Fairly quickly, here is our agenda for today. Now, I know it's originally scheduled for 2 to 4 p.m., but hopefully I can get through all of the content within the next 40 to 45 minutes, open it up for 10 to 15 minutes of questions, and then we can have you on your way to continue on with the rest of your day. But if not, at least we have until 4 p.m. in case we run over, and in case we get into some pretty informational and lengthy discussion today. So here's what we'll be going over. Specifically here, what is most important for everyone to be aware of is what's happening with our Office of Labor Standards of Enforcement Department in the Santa Clara County region. So all of you who have businesses here in Santa Clara County, it would be helpful for you to know what's happening. There's also some updates to our minimum wage requirements, some new leave of absence laws, workplace health and safety, now that we are, fairly out of the COVID situation. I mean, I know it's still out there, but there are very minimal and nominal requirements now in terms of COVID safety protocols for the county and for the state of California as of February 28th, 2023. So giving you some updates on that. And of course, a friendly reminder around harassment prevention, discrimination training. There's new laws around transgender rights, time to vote rights, as well as updates to some of your responsibilities as hiring new employees and your minor hiring, because I know we've got a labor shortage out there with workers, especially in the small business space, and some of us may be hiring minors that are under the age of 18. So understanding what your requirements are there for hiring those. So let's start with our sources of truth. This is a really good page that I like to share with everyone in regards to where you can specifically get information around the federal, state, and local laws that you need to adhere to and how often they are updated. So I know all of you as small business owners are very busy with their day-to-day operations and being able to ensure that your business is profitable, but also staying in compliance is going to be key. So here are some departments that you want to make sure that you are currently aware of, that you can access some really great information to support you in your business. So up at the top left-hand corner, you're going to see OSHA. So that's the Occupational Safety and Health Administration. This department has become widely popular in the last 2.5 years, especially with the CDC, because of the outbreak of COVID within the workplace, right? So OSHA is a really great website and federal department that you can have as saved as one of your favorites, especially if you're looking for updates around how to maintain a safe workplace environment within your business. There is even information in the OSHA website around workers' compensation and any sort of injuries that take place in the workplace if, for example, someone gets hurt on the job. So there's information with OSHA that you can access to go through an investigation of a workplace injury, as well as anything that you want to put into place for your workplace safety protocols. Right in the middle, you're going to see this little balance with the Department of Fair Employment and Housing for the state of California. So this is formerly known as FEHA, Fair Employment and Housing Department. They are now the California Civil Rights Department, or the CCD. So this is a really great website to access, especially when you're looking at discrimination laws, harassment prevention laws, different changes in the law in the state of California around transgender rights, as well as things around retaliation. So being very aware of this department, which is now the CCD, or Civil Rights Department, CRD, Civil Rights Department, is important for you to be aware of. I mentioned up here in the right-hand corner, the CDC, or Center of Disease Control, which is the federal department, but also more importantly, for the state of California, you'll see in the middle, Department of Public Health. So the California Department of Public Health, again, is a really great resource to access, especially if you are printing out posters for safety protocols within your business establishment. I know that was very important with the 6 feet distancing, or even just simply, hand health, washing of your hands for your employees and things of that nature. So that's a really great resource to utilize. IRS in the middle right here is anything involving your tax implications, as well as right below it, you're going to see the EDD, or Employment of Development Department, or State of California EDD, because these two groups go hand in hand, one involving taxes and payroll taxes that you're required to submit per state law and federal law, and then EDD pertains to unemployment taxes or anything that you need to submit in terms of disability taxes, etc. So all of these two kind of departments go hand in hand, and I like to share their information together. And I'll have a slide a little bit later on to be aware of in regards to unemployment, as well as employee classification and whatnot. Towards the right here, you're going to see Department of Labor, or the DOL.gov site. This is very important in understanding all of your federal law requirements. CA.gov is just a general good site to access as well for all California state laws. And then you're going to see here in the lower left-hand corner, the EEOC, or the Equal Employment Opportunity Commission. This is where they talk also about various discrimination laws, ensuring that you're adhering to sort of diversity, equity, and inclusion requirements if you are of a business of 26 employees or more. There's also this department that helps with lawful terminations or unlawful terminations and being aware of what your rights are as an employer to ensure that you're doing everything accordingly to the law when it comes to terminating employees as well. Because as we know, in recent weeks and months here in the Valley, in Silicon Valley, there have been large terminations for some of the tech companies, the big tech companies, and the EEOC needs to adhere. There's lots of laws there that you want to adhere to and make sure you're up to date on in regards to how to go about doing that lawfully and in accordance with what's required. So really great places to access, and I'll reference some of these sites as we go along in our presentation. So let me move on to what's happening here in Santa Clara County specific. We have in Santa Clara County a Office of Labor Standards of Enforcement, or the OLSE or OLSE. You can access them via Instagram. They have their own site. SCCFairWorkplace.org is their website. They've got great staffed advice lines for both employees and employers. So you as a business owner can access their free advice line at 866-870-7725 to speak with an attorney if you are running into any sort of issue within your workplace that you want to talk with a live attorney for. This organization, specifically here in the county, was established in 2017. And the main goal of the OLSE or OLSE is to really advance the labor standards within our communities so that we can really come together as a healthy economic environment for both employers and employees, and actually have a thoughtful community that works together in terms of innovation, study, research, policy, commitment, etc. So really a really great group, and they are currently out there, communicating to a lot of work establishments and doing outreach, understand what sort of labor laws they need to be on top of, what they need to adhere to, and then also understand what everybody's rights and responsibilities are in regards to adhering to the standards of the business. Now, if you have not yet downloaded and updated your labor law posters, this is really now a great time to go ahead and do that. Here right below, I do have a free labor law poster link that you can access where you can print out any of your updated posters that you need to put out there. But also remember and keep in mind, digital or electronic copies also need to get sent to your remote employees in the state of California as well. So if you've got, someone sitting down in Southern California, or maybe you are outside of the state as a business and you've got employees within the state of California, they still need to adhere to state of California guidelines, and therefore you still need to send them the updated electronic versions of the 2023 posters that all of your employees need to be aware of. And of course, if you are posting it in your business, it should be in a very obvious area like a break room, near the restrooms, anything of that nature, so that all employees can see the updated labor laws for the new year. Very briefly, I have a rundown for California labor laws that are updated as of 2023. So minimum wage, which we will go into more detail about, is definitely new. Some of the other things here are the pretty basics, the unemployment insurance information you want to have posted, health and safety protocols and emergency phone numbers you want to have posted, access to medical records. As a pregnant employee is something new, and family care and medical leave is new in terms of your postings. Workers' compensation information, again, if your employees, just in case, get injured in the workplace, that needs to be posted. As of last year or a couple of years ago, we've got the time off to vote, whistleblowers protection, California paid sick leave, and then transgender rights in the workplace. And mainly for the transgender rights in the workplace, the poster just discusses how they cannot be discriminated against. They should be allowed to wear what they want to wear in the workplace. And there shouldn't be any retaliation for, who they are and how they represent themselves. So all of this is part of the new labor law posters that need to be up in, again, common areas, common accessible areas in your workplace, or emailed out to remote employees if you have people working from home. For federal labor law posters, just as a reminder, you've got the FMLA, or the Family Medical Leave Act, that wants to be up there. Fair Labor Standards Act, which is the FLSA, or your non-exempt and exempt status, that needs to be up there. Uniformed Services Employee and Reemployment Rights Acts, or your SARA. Know Your Rights and Workplace Discrimination is Illegal, EEO, which is also a new poster. Occupational Safety and Health information, as well as Employee Polygraph Protection Act. So most of this federal labor laws posters, everyone I typically see in the small businesses that I go to visit will have these up. Just be aware of what is new, which is the Workplace Discrimination is Illegal poster that you want to have up there. And then for local city ordinances, so not only do we need to adhere to federal law, state law, but here in the Valley and Santa Clara County, we have local city ordinances you want to be aware of as well. So you want to definitely have your minimum wage rate poster updated and up to date every year in your, again, area. San Jose specifically has an opportunity to work ordinance. You'll see a little copy of that there that I've snipped out and posted there. That needs to be up for any business that is established in the city of San Jose. For any of you businesses that are located in Mountain View, we've got a wage theft ordinance that also needs to be posted. And then in the past, some of you may have had some COVID supplemental sick leave posters that were up and running and up and required to be posted. That is no longer a requirement, again, as we've switched off into the new year of 2023. So you can certainly take any COVID supplemental sick leave ordinance posters down because those are no longer needed. I'm going to take a break here for a brief moment and see if there's any questions in the chat, but I'd also love for some of you to just list out what local or cities are you currently experiencing this webinar from. So which cities in particular, just so I'm aware of which cities and businesses are part of our conference call or virtual workshop today. I will take a brief moment to take a look. Saratoga, great. Oh, and I should say, if you wouldn't mind also listing what type of business are you in? Are you in the restaurant business? Are you in what industry? Is it retail services, online, anything at all that you can share with us in the chat that you are currently located as far as the city is concerned, and as well as what industry you are in. Okay, great. That just helps me tremendously in understanding as we start to go through further in our presentation. All right, great. Loved seeing everybody's responses here. Wonderful. Okay, theaters, yes. Financial, hotels, cleaning service. Great, thank you. Okay, and so let's talk first and foremost about the Fair Labor and Standards Act, or the FLSA. I don't expect you as business owners to know any of the specific acronyms here. I'm just merely giving this out for general information. But what the FLSA, which is a federal governed law, is about is pertaining to employee classifications and understanding how to correctly classify your employees. And
Hey,
this
Melissa,
yes.
your screen sharing closed.
Oh, hold on one second. Great. Okay, here we go. Perfect, thank you. So yes, let's move on to the Fair Employment Standards Act, or the FLSA. And again, like I mentioned, this is all about employee classification. So really considering and thinking about how you are classifying the people that you currently have. This was very, very popular, I believe in 2020, when first and foremost, the AB5 law went to an effect in January of 2020, which by default requires all workers to be employees within your business. Okay, so an employee means they fill out a W-4 form, they are on your payroll records, you submit taxes for their, federal, state, whatever it is they need, and you will have them, and you're processing their payments through your payroll provider, or directly hiring them as a worker and employee of your business. This law had a lot of controversy because a lot of folks were thinking and feeling like, well, we like hiring independent contractors because they're only working a couple hours a week with us. Well, that is no longer the case. If the worker that is in your business, regardless of how many hours they provide you on a weekly or daily basis, if they are a worker that contribute to the bottom line of your business, meaning, let's say, for example, obviously restaurants is fairly easy, retail service providers is fairly easy, but let's talk about maybe, for example, a service provider like a financial insurance agent, or a social media company, or a theater, for example. I saw in the chat, some of you are from the theater industry and whatnot. Anyone that you hire to work in your business because they are contributing to your bottom line, meaning they are the ushers, they are the vendors for, providing ticket sales. They are the ones giving out snacks in the snack booth or whatnot. And again, if you're a social media company, or let's talk about a videographer, or even a musician, for example. These people are your camera guys. These people are your actual artists that are, you're performing with you in your band. Or again, someone that just works directly with you in research and development. These are all going to be W-2 employees unless they can pass an ABC test. And the ABC test here is where A, they are free from control and direction. B, they perform this type of work outside as well with maybe other businesses or other entities. And C, this can be an independently established trade, occupation, or business. So they must pass all three of this, A, B, and C, to then be deemed an independent contractor. So again, if you've got a workforce of predominantly independent contractors versus W-2 employees, I highly, highly recommend you revisit that and take a look, because many of those independent contractors may need to be converted over to W-2 employees. I'll give you all another example, and this was somebody that I recently spoke to and consulted with. They own a dance studio, and they bring in, quote unquote, in the past, independent contractors to be dance instructors. That is not allowed any longer, because the dance instructors are very important to your bottom line. Without the dance instructors, you will not have a business, and you will not be profitable, because your dance instructors help contribute to the bottom line of your business. Therefore, even if they come in and work 1 hour a week, even if they come in and work 2 hours a month, they should still be considered W-2 employees every time they come in and instruct a dance class for you. So again, this is all under the new law, and the EDD, which I mentioned earlier, the Employment Development Department for the state of California, has unfortunately been sending out audits and audit requests to small businesses that have not been classifying their workers properly. So not only do you not want to be fined for employment misclassification of workers, you also don't want to have to go through the nuance and the time-consuming audit that is really unnecessary for your business. So be very careful in terms of how you're classifying your employees and who's a W-2 and who's an independent contractor. The other misclassification of workers is our hourly or non-exempt and salaried employees. So by default, especially for the people and purposes of our audience today and the small businesses we have in the county, I would say by default, it is mainly an hourly employee that you are more than likely hiring within your business, right? So retail sales, restaurants, IT people, you would normally have them work on an hour by hour basis. So they are considered non-exempt employees. However, on the off case, you have some of your more senior positions like a restaurant manager, an IT manager, a t-shirt or warehouse coordinator or administrator. You may consider them to be a salaried employee instead. And by salaried, it means they are exempt from overtime. So as salaried employees are exempt from overtime, they're exempt from meal and break periods. You as an employer or business owner do not necessarily have as much control over what they need to get done on an hourly basis. It is more about here's your job description, and here is what is going to be required of you to get the job done. And you just need to get the job done regardless of how many hours are worked. And that's why they are considered salaried or exempt. Generally, like I mentioned earlier, these are more higher level positions like supervisors, administrators, operating executives. And then keep in mind, there is a requirement to make sure they are paid at least $1,240 per week or $64,000 a year in terms of a salary, because again, they are being allowed to work no matter how many hours that is required to get the work done. So they don't normally, they may work some less than 40 hours a week, but majority of them probably do work more than 40 hours a week, which is why they're exempt from overtime and which is why there's a minimum pay requirement in terms of what they should be making per year. Okay. And then here are the non-exempt or hourly employees. Again, you as a manager or a business owner have more control, and you assign tasks to them. You require how many hours that they're going to be working. You tell them that the tasks that you're giving them should be completed within a certain number of hours. This is where I mentioned earlier, the IRS and the EDD have some really great resources in terms of classifying employees correctly, and just be aware that misclassification of any worker can really lead to, fines and fees and audits that you really do not want to have or worry about as a business owner. So really ensure that right before you are hiring a new employee, you're clear on what type of classification this employee is going to be. And then remember, keep in mind, in the city of San Jose, for those of you businesses located in San Jose, there is a ordinance or local ordinance that for any additional work, so that's the opportunity of work ordinance, for a part-timer, you always want to give them that opportunity to actually take on additional hours before hiring another part-timer to come in and do that work, right? So that's the local ordinance in the city of San Jose for part-timers being offered the opportunity for additional work prior to hiring a new person on to do that additional work. Should be allowed and offered to any existing part-timers that you may have within your workforce. So fairly quickly, here's a rundown of a new employee checklist. You obviously have to have an EIN in order to hire your employees. There's the link there under edd.ca.gov that you can access to get the EIN. You should be able to find a payroll provider, or you can actually process payroll yourself with your local accountant, bookkeeper, or CPA if you don't have a long enough or large enough employee base. But otherwise, some key common ones that a lot of our business owners use are ADP, Paychex, Gusto, QuickBooks is now doing payroll services. So always access and see what's available out there. Ensure your payroll provider sets you up with the proper unemployment disability payments for EDD. I've run into some situations where sometimes the payroll provider, if it is a local CPA or a bookkeeper, they were not processing proper disability payments for some of the workers. And of course, they should help you with how to go about making sure payments are done for Social Security and Medicare for the federal side of things as well. You also want to have any of your new employees fill out an I-9. This is a federal form. You can just Google I-9, which states that you are legally qualified to work in the United States. So an I-9 means they have proper documentation, whether they are US citizens, permanent residences, or work or student visas. So you can always make sure that that I-9 is completed. I mentioned earlier a W-4 for tax purposes, so that all your W-2 employees get the proper deductions made on their taxes. And if you have direct deposit, ACH is possible as well, where you can help your employees just automatically get direct deposit of their paychecks. New for June, as of June of 2022, and it is still continuing to be ongoing through 2023, and also may change in 2024 and 2025 for employees of 5 FTE or more, or 5 workers or more. You are required to offer a retirement plan to all of your new employees. Retirement meaning they can start saving and putting aside money from their paycheck towards a retirement plan. Now, if you have one that's being offered by your payroll provider, great. If you have one that you would like to use because you utilize it for your own financial services or financial investments, you can also inquire about what your current maybe financial investment providers have to offer. But if you do not have one right now that you are giving to your employees, and again, you employ 5 or more staffers in your workplace, CalSavers is another free, very easy, low cost, no cost retirement program that you can also utilize for your employees, where they can start saving for their retirement. And I listed there the calsavers.com site for you to access at your leisure. Please be aware that the retirement program or the retirement plan should be offered to your new hires within 30 days of hire, so that you can start properly deducting any retirement savings they want to set aside in their paycheck after 30 days. So ensure that is a benefit and something that you are expressing and sharing with your new employees. Workers' compensation insurance, of course, absolutely needs to be provided, as well as any copies of harassment prevention and discrimination policies within your workplace. Hires, if you have a new hire packet or handbook, they should all be given all of this upon hire, so that they are aware of what your specific policies are around all of these areas. And then, of course, again, if you are employing 5 or more employees, there is a harassment prevention training that is required within 60 days of hire for all of your employees. And then if you are a supervisor or business owner, this harassment prevention training needs to be completed every 2 years you are in business and you are overseeing a staff of 5 or more employees. So make sure you're aware of doing that every 2 years as a business owner. And then new for 2023, and this is something new, when you are out there posting your jobs, and let's say you are a business of 15 or more employees, your job posting, so you know how you have a job description that states, here are the job description and what's going to be required of the job, and then you have right below it some of the job qualifications. You now need to also post what is the pay range for this particular job. So again, if it's an exempt position, what is the pay range? It's 64,000 to what? 80,000, 64 to 90, whatever the range is going to be in terms of what you will be paying the hired individual in that job. And if it's a non-exempt position, is it $16 an hour to $22 an hour? Is it 18 to 25? Whatever your range is going to be, you need to put that also in the job qualification section, so that it is out there and transparent for anyone to apply. And then if you are a business of 15 employees or less, or 14 employees or less, I should say, you do not necessarily need to have it posted on your job description, but you do need to have a bullet that states pay range requirements or pay range available upon request. So if at any point during the interview process, one of the interviewees wants to ask roughly how much does this job pay, you can easily spit out. It pays, $25 to $45 an hour, or it is a minimum of $64,000 a year, something along those lines that you can at least communicate to them what the pay range is. So this is required and is a new law as of 2023 for job postings as you are out there hiring new people for your business. So now let's take another quick break. I'll pause to just see what questions are in the chat, and then we'll move into wage and hour requirements for the business. Anything thus far? All right. Let's take a look here. I see some questions around the 1099. Oh. Would that include a bookkeeper? They have other clients come and go on their own schedule. So that was one of the questions earlier. So if the bookkeeper has their own business, the graphic designer has their own business, the social media strategist has their own business, they do not need to be a direct employee or W-2 employee of yours, because you are now hiring them as a vendor instead. So then they can stay as an independent contractor. And yes, you would still provide them with a 1099 as a vendor. So they're considered your vendor instead. So hopefully that clarifies with regards to bookkeepers. Because yes, I get that question a lot. Well, I don't need to hire my bookkeeper, do I? Or my, social media strategist. No, if it doesn't pertain to your bottom line of your business, then no, they can continue on as a 1099 or independent contractor. And they have other businesses that they support in that same capacity. Any other questions when it comes to misclassification? Wonderful. All right, so I will continue on, go back to sharing my screen. Okay, so let's now talk about wage and hour requirements. This is all about minimum wage, overtime, meal and rest periods. And again, this is all pertaining to your non-exempt or hourly employees. So just some history on how the California state minimum wage schedule has increased through the years. As you can see, for January 1st of 2023, we are now at $15.15 for the state of California. Okay, it's going to start going forward at an annual inflation of around 3.5%. That's a rough estimate, but that's something that they know they are negotiating, and they have a formula that they're going to be utilizing every year for the sake of inflation to ensure that minimum wage requirements stay in line with the annual inflation rate. For us in Santa Clara County, we have very specific local minimum wage ordinances. And so here I've posted a number of them here on this site. So you'll see Mountain View, Sunnyvale, $18.50, Palo Alto, $17.25, San Jose, $17 as of this year, Milpitas, which just raised their minimum wage at $16.40. And keep in mind, they raised theirs in July, not in January. That's why I put a little asterisk there, along with some comparisons to our neighboring cities of San Francisco, which is $16.99, or it's essentially $17, and Oakland, which is essentially $16. So just for your highlighted information, because of our higher cost of living here in the Valley in the county of Santa Clara, this is the minimum wage for us, and anywhere else that is not listed or does not have a local city ordinance with minimum wage, they go to the default of $15.50 an hour, such as Campbell and Gilroy, which is following within the state of California guidelines. Now, the OLSA, or the Office of Standards, Labor Standards of Enforcement, again, I referenced their website earlier in our presentation. They have this handy dandy handout. So if you just wanted to print this out from their webpage or download it from their webpage, all of it is up to date. As you can see, Milpitas again until June 30th of this year will be $16.40, but that will then go up again in July 1st of this year, and all the other locations you see there as well. Okay, there used to be an ordinance of $15 for 25 employees or less and $15.50 for 26 employees or more. That has now gone away. It is a standard $15.15 for all employees, regardless of how many employees you have for the state of California. So be careful on that front, because some businesses might say, well, I thought it was $15 because I'm only a workforce of only 10. No, that's gone away and they're below 25. It is now $15.50 for all, regardless of how many employees you have. Timekeeping. This is always a really great reminder I like to share with all of my businesses, because a lot of times they set schedules. If you've got, let's say, a retail store, a restaurant, or where you've got several employees coming in for shifts, you set their schedule for when they need to maybe be customer facing. Maybe they need to be front of house. They need to be with the customers. So once you start their shift, please keep in mind, they may need time to change into their apron. They may need time to unbox boxes and inventory in the back. They may need clock in time work to turn on the yogurt machines, or anything that has to do with just preparing for the business to turn on, to log in and set up their workstations. Clock is ticking and time is worked once they are doing anything pertaining to your business. Another thing to keep in mind, I know I've had this example in the past for those who work booths or exhibitions or farmers markets. Please keep in mind your employees or your hourly employees, their time starts when they have to travel to that exhibition. Let's say you have a trade show, in San Francisco. The time clock starts when they have to travel to that trade show, or the farmers market, in downtown Mountain View. Time starts for that worker as soon as they are trying to travel to that farmers market, especially if that is not your main place of business. You've got a headquarters somewhere, you've got an office somewhere, you hold team meetings someplace else. That is actually where their main location is. So you do not have to pay them to go to your main location, but you do have to pay them for time traveled to certain trade shows and whatnot off-site. Employee meetings also is required to be paid time, or even on-call hours. We've had a situation where delivery folks, I know DoorDash and Grubhub is pretty common, so they're third-party vendors, but some of our own business establishments, I have a sushi restaurant in downtown San Jose that has their own delivery people. If you've got that delivery person on standby and not actually making deliveries for your business, that is still considered time work. So please ensure you're compensating for the hours that they are at your business establishment waiting to make deliveries for your business. Overtime in the state of California, please be mindful, is obviously 8 hours in the day. This particularly came up as an issue because some folks were using ADP or paychecks or have multiple businesses across the United States, and not being aware and mindful that state of California's overtime laws are any hours worked more than 8 hours in a day versus, let's say, the state of New York or other states outside of California. They may be offering overtime, anything worked more than 40 hours in a week. So California is much more strict because it's overtime over anything 8 hours in a day. And some of our national payroll vendors like Paychex or ADP tend to sometimes overlook this or forget that we're in the state of California and may not be paying your overtime workers what they are owed. This is also inclusive of double shifts. So we may have businesses that decide, I'm open for lunch service, so I have them working 11 to 2 or 11 to 3, then we're closed, and you have those same workers working from 6 to 8 or 5 to 9 p.m. for dinner service. Please be aware, anything over 8 hours in a day includes double shifts or 24 hours rolling period. So therefore, anything beyond 8 hours inclusive of their wait time, so you don't pay them for the wait time, but anything beyond the 8 hours inclusive of the wait time starts to become overtime, which is paid at time and a half, their hourly pay. If you've got workers working a 6th and 7th consecutive day, so let's say you've got them coming in Monday through Saturday, but they're doing 5-hour shifts, the 6th day is considered a consecutive day, which also gets paid in overtime of 2 times their hourly pay. So being mindful as well as how you're scheduling your workers, even though they may not be getting overtime, but if they are not getting at least a day off or 2 days off in terms of their work schedule, they may also be qualified for 2 times or 1.5 times their hourly pay. Pay summaries in the state of California are going to be required at all times. So for every pay period, whether you're paying them twice a month or just one time a month, and even if they have direct deposit, a pay summary should be provided so they can see what hours they have gotten paid for, and also what do they have remaining in terms of California paid sick leave, and if you do offer PTO or paid time off as a benefit to your employees, what are those balances or running balances they have remaining for the year. And be aware, when you decide to terminate an employee, you decide to fire someone either for lack of performance or attendance issues or anything egregious where they really treated the customer bad or whatnot. Once you've terminated that employee, you need to provide them with their final pay and all due wages that they may have, maybe, again, California paid sick leave they did not use, or PTO balances they did not use, need to get provided to them upon the communication of that termination. So check in hand. If it is a voluntary termination because they themselves have decided to quit, then you as the business owner are obligated to pay them within 72 hours of their communication to you that they are quitting. So voluntary requires 72 hours, involuntary requires check in hand. There are some unique ways that we manage this from an HR perspective, especially if, let's say, you want to fire them on the spot, but you need another hour or another day to go through some administrative processing of a paycheck. Then you would just hold off. You could put them on unpaid administrative leave and communicate maybe the day when you have that check ready to avoid any fees or fines or penalties of not paying them on time.
Melissa, I'm going to jump in here. We've got a few questions I'll read to you, if you don't mind.
Yes.
Elizabeth is asking, is the harassment training separate from sexual harassment training? She says she does not know about did not know about the 60-day rule.
It is the same. I just call it harassment prevention training now because it doesn't necessarily mean only sexual involvement. So harassment prevention involves everything. And yes, historically, it has been called the sexual harassment training.
Okay, and Corey has another related question. How frequently do non-exempt staff need to take the harassment prevention class, and is that yearly?
They say it's a best practice to do it yearly, but as long as you have documentation that they've completed it, it's fine. It's more the requirement or legal requirement is for supervisors and business owners that need to have it done every 2 years. So the legal requirement is to have supervisors and managers do it every 2 years. For staff and regular employees, it could be a best practice to have it done yearly if you'd like.
Okay,
But there's no legal requirement for that.
Perfect. Got 2 more here. What does the minimum salary for exempt employees change based on the local minimum wage, or is it still federal minimum wage?
It's federal minimum wage.
Okay. And then how do you deal with paid holidays in retail areas? We are open 7 days and open many holidays, but they do not work 5 or 6 days in a row. Do we still have to pay double, even if that Monday was a normal schedule for them? For instance, they only work Sunday and Monday, and Memorial Day is on a Monday. Does that employee automatically get 2 times?
Oh, okay. So paid holidays, I should be clear on this. That is only if you are offering paid holidays. Holidays do not need to be paid. I apologize for that. For clarification purposes, I should probably make an edit there. Federal holidays are any holidays that are practiced or observed in the country. And I know the state is starting to come up with their own observed holidays as well. They do not necessarily need to be paid. I know government employees will pay them, but for retail, small businesses, they do not necessarily need to be paid. So if the Monday, which falls on a holiday, happens to be their regularly scheduled work day, you do not need to pay time and a half for that. It can just be considered their regular straight standard hourly pay. Now, for retention purposes, if you'd like to implement a holiday pay structure, because it's a nice to have and a nice to give your employees some extra bonus, then that is up to you, and there's no legal requirement around that. That's really for you in terms of how you feel you want to support your employees of having them work on holidays.
And I have one follow-up question left here. It's regarding the harassment training again. Says
Yes.
the 60-day requirement is only for new managers and not for all staff, correct?
It should be for all staff, for all employees, but I will double check that for you. But more than likely, that's for all new employees.
So,
Will they ding
right.
you for not having it done within 60 days? No, but it's just one of those things that it should be all employees have it completed within 60 days, because you don't want something to go off the rails if not done within a timely manner.
Sorry, Melissa, this is Corey, and I just want to clarify my question. So I thought I just heard you say the only legal requirements are for managers to have it done every 2 years. Is that accurate?
Correct.
So
Yes.
So the 60-day requirement is actually just a recommendation. It's not a requirement for non-managers.
For non-managers, it is a requirement for within 60 days. For non-managers, within 60 days of employment.
I'm so sorry. Just one more time. Does anybody else sort of understand why I'm getting confused here? So you just said that the only legal requirement is for managers every 2 years, and the rest of it. But then you just also said that new hires need to have it.
So
that
new
is
hires,
also a legal requirement?
I will double check if it is a legal requirement or not, but I think you still want to have it done for all new hires within 60 days, because you don't want to run into the risk of something happening beyond the 60 days within your workplace, right? And they have not completed the training. So the 2 years for managers and supervisors and people that oversee employees, that is a legal requirement, correct? The within 60 days, I will double check if it is a legal requirement, but from what I recall, it was, but it also may be a best practice. However, nonetheless, you still want to make sure all of your new hires do the sexual harassment training within 60 days, because you don't want to put yourself in a position where beyond 60 days something happens and they haven't been trained on it.
Okay, that's helpful. I just needed to understand.
Yeah.
So you're basically saying you don't know about the legal requirements, but you're saying to cover yourself in other ways as an employer, it's highly recommended. Got it. Okay, I understand. Thank you so much for that clarification.
No problem. Any other questions?
Got another one in here in regards to sick time. Are we required to pay unused sick time? Is that for termination? I do not know. They did not specify.
Yes, for both involuntary and voluntary terminations, you are required by law to pay unused California sick time. And I'll go into more about the sick leave and what it can be used for, and how, what it can be used for. But yes, you are required to pay unused sick time.
That's all we have right now.
All right, thank you. All right, so meal and break periods. So again, going through meal period for hourly employees. Meal periods are required for a minimum of 30 minutes for employees that you have working 5-hour shifts or more. Preferably that meal period should be in the middle of the shift. The meal period also must be uninterrupted. So a lot of times what happens is an employee goes to the back of the break room, takes their 30 minutes of unpaid meal break, but then, oh, come to the front, you've got a customer here, or come grab that shipment real quick, the vendors delivering their boxes or whatever it may be, or the food or ingredients for the day. So now that becomes interrupted. And if it is interrupted, be aware you still need and owe the employee the full 30 minutes of uninterrupted meal break. As best as possible, if you can have them leave the premises, because we can't prevent them from being interrupted. If they stay on premises, that's highly recommended. But yes, uninterrupted 30-minute meal, unpaid meal period is required by law for 5-hour shifts or more. If they are, of course, working a 10-hour shift, then of course a second meal period is going to be provided. And if a shift sort of ends within that 5 to 6 hour mark, you and that employee can come to a mutual agreement that they will forego their 30 minutes of unpaid meal period, but then tack it on towards. So then they're leaving at 5.5 hours with that 30-minute unpaid meal period versus the full 6-hour shift. So if that is something that you are going to come to agreement with an employee with, just make sure you've got that documented, the date that was requested, and it was preset for record keeping purposes. So again, both employer and employee can mutually agree to waive their meal period towards the end of like a 6-hour shift so that they can, work the 5.5 hours instead. Rest periods or breaks are 10 minutes for every 4 hours worked, and there is no deduction of wages, so that they just get their 10-minute break paid. So for every 4 hours, they get their 10 minutes, they can step away, go to the bathroom, use their cell phone if you've got a strict cell phone policy, anything along those lines, and they are required to be given that rest period for 10 minutes. There are some exceptions for rest periods, very, very, very minimal exemptions where there is an undue hardship for the employer to provide them with that rest period. Again, this goes back to our farmers market folks, our agricultural workers. I think from the chat, nobody necessarily was in the agricultural business, but speak up or put it back in the chat if you are. These are where there will be some nominal exemptions to the 10-minute rest period, and there could be potentially some premium pay involved in that. So just be aware if you forego any meal or break periods for employees, there could be some penalties in the premium pay that you pay them. So now let's go into leaves of absences and paid time off requirements. So this is all going to talk about the California paid sick leave, which I love that people already brought that up. The California Family Rights Act, or CFRA, CFRA, disability leave, bereavement leave, which is something new also for the state of California in 2023. So first and foremost, let's go with California paid sick leave, which is a mandatory legally required benefit that you are providing to all of your employees, regardless of how many hours worked they are working for you. Now, there are two ways that you can administratively provide this paid sick leave. You can either give them 1 hour for every 30 hours worked, up to a maximum accrual of 48 hours. So if you were willing to track it, and again, this is specifically, let's say, for your dance studio or dance teachers or tutors or retail workers that only come in once a month or 3 times a week, 2 hours a week, very, very nominal. You definitely want to probably utilize the accrual process now. However, that is going to be an administrative nightmare that you might want to pass on to either your payroll provider or an admin or someone that can track these hours for those types of workers. So that's option 1. Option 2, which is the least headache, is just giving all of your employees a lump sum of 24 hours every 12 months, every calendar year. And you probably might want to do a 30-day waiting period just because they may not accrue the full 24 hours within the first month of working with you. So 24 hours is what they will be eligible for paid California sick leave. Now, there have been some changes to the law, but just as a clear-cut summary from where we are right now, paid sick leave can be used for an employee's own sickness, sickness for a spouse or domestic partner, or even a child that they have at home that is sick. And it has now been allowed for caregiving. So you've got a parent, a grandparent, or even the child that has been, I know this was very popular during COVID, that they had their school closed. You need to now caregive for the child because of the school closure, and therefore you can also use your California paid sick leave for these purposes as well. Half of their annual accrual of California paid sick leave will go towards the care of a child, sibling, parent, child. And even if they have specific personal days or needs, like a concert that they need to attend, like I'm just giving you an example, an honors ceremony that the child needs to attend, or a concert that they're performing in their choir or orchestra, you can use half of your annual accrual from the California paid sick leave towards this. Okay. Again, it is paid out if the employee leaves and it is not used. And as a reminder, only the employee can designate whether or not they're going to be using sick leave. You as the employer can ask, will you be using, should I deduct this from your California paid sick leave? You can ask that and they can say yes. But if they say, no, I don't want that, like I'm caring for my spouse who's sick at home, would you like this to be removed, deducted from your California paid sick leave? If they say no, just consider it me unpaid, or I'm a call out or an absent, then therefore you don't necessarily have to pay them the California paid sick leave. It's only at their designation would you pay it out. Again, reminder about what the employers must provide, and depending on which option you've decided, whether it's the accrual option or the lump sum, it should be properly provided to all employees in one set standard. And again, as a reminder, half of their annual accrual can be used towards a family member. Even if it's not them being sick themselves, they can get paid for, again, having to care for someone directly within their family. COVID supplemental paid sick leave. Now, this was something that came out of the COVID protocols, and I'm not going to go into detail on this because it did expire last year, but I wanted to make sure everybody who did have to pay this out was aware that GoBiz, so the California State GoBiz site, is providing a grant for small businesses who had to pay out the COVID-19 supplemental paid sick leave to their employees that were out for COVID. So keep an eye out on that. That is coming soon. As of today, I did not see anything on the GoBiz website, but if I see something shortly, I will make sure it gets sent out to Crystal and the rest of you at the San Jose Chamber in regards to what is available as a grant is concerned for anyone that has paid out supplemental paid sick leave in 2022. Leaves of absences. So now let's talk about the Family Medical Leave Act, pregnancy disability leave, jury duty leave, any sort of leave of absences that are required to be given to an employee. So the Family Medical Leave Act is the federal law that requires us to be providing a 12-week unpaid family medical leave if someone is ill, desperately ill, is not able to come to work, they've got some kind of chronic disease or illness they're dealing with, they are allotted up to 12 weeks of unpaid FMLA. Now they do need to meet time requirements of having worked with you. So it's roughly about 1,200 hours a year or up to 12 months in a year. So if they are a new employee, they may not qualify for the Family Medical Leave Act. But if they are someone that has been with you for years and years and years, and they are now dealing with an illness or even an illness in their family, they could be eligible for unpaid family medical leave. Okay, FMLA is a federal law. You can find more information on that on the Department of Labor.gov site. But California specifically offers the Pregnancy Disability Leave Act, or PFL, or disability leave that can be paid and administered through the EDD. Okay, so those are slightly two different laws because one's federal, one is state specific, but the state specific one is very similar to the federal one, where it's up to 12 weeks of unpaid leave. But once they go onto the EDD site, the Economic Development and Disabilities Development department site, they may be eligible for some replacement pay, especially if they are unable to work due to pregnancy. So something to keep an eye out in terms of offering your employees that are eligible for pregnancy disability leave to go onto the EDD site to apply for paid benefits. You as the employer do not necessarily have to pay them for these leaves, or you do not have to pay them for these leaves, but they can get supplemental or replacement pay through the EDD. Okay. Other types of leaves of absences that we want to provide to our employees, again, jury duty leave. There's domestic violence leave if anyone's dealing with a domestic violence situation and they need to go to court for some reason. We are providing our employees with that type of leave to go do that in court situations, and time to vote leave. Now, for jury duty and time to vote leave, there are specific cities and counties that might be able to pay the employee for their time away from work. Especially in Santa Clara County, I believe they give some kind of stipend of $50 per day they miss work for jury duty. Time to vote can be up to 2 hours pay if they need to leave work to vote, and they can't do it outside of work hours. And then new in 2023, we have a bereavement leave, which is up to 5 days unpaid that a worker can miss due to bereavement of a family member. And again, family member can be defined by parent, grandparent, child, sibling, and even a parent-like individual. So maybe people have been raised by their aunts or their uncles. So someone close to them that they would consider a parent-like individual, they will be able to take up to 5 days of unpaid bereavement leave in any event. Now, again, as an employer, your employee should provide you with some sort of reasonable advance notice, if possible. You can ask for written documentation, like for bereavement leave, if you want a service or an obituary as proof, you can ask for that. Time off is unpaid unless you do have a policy where you are providing PTO or vacation pay to your employees that they can utilize for some of these leaves of absences. And of course, we cannot retaliate against our employees that take advantage of some of these leaves that are available to them, meaning we can't write them up for attendance issues or demote or fire them. It's just all about ensuring that we are giving them the reasonable time that they need in order to adhere to any of these types of leaves that they want to utilize. Okay, and for family medical leave and pregnancy leave, one of the key things to consider is that even though they are unpaid for up to, let's say, 12 weeks of unpaid family medical leave, or pregnancy leave, they do need to be returned to the same position, same working environment. And you can hire somebody to maybe backfill someone who's out on maternity leave, for example, but once they are ready to return to work, they need to be reinstated into the position that they specifically left prior to going out on leave. So please keep that in mind, because we've had some folks say, well, now their job duties have changed and now their job location has changed. And no, they need to be legally required to be reinstated into the position that they were in before leaving. This again talks about CFRA, or California Family and Medical Leave Family Rights Act. It's very similar to FMLA. It expands it so that there's 5 or more workers that are eligible for this. Like I mentioned, there's a minimum requirement where they need to have been working with you for at least 12 months or 1,250 hours. They can take up to 12 weeks of unpaid job protected leave. Serious condition, other conditions of family members, even the birth or adoption or foster placement of a child falls under CFRA. And an employer can request for certification and must be reinstated to same or comparable position. One other thing to consider also on SIFRA and FMLA, it can also be taken intermittently. So it may not necessarily be the up to 10 or 12 weeks all at once. It could be, well, I'm dealing with my medical issue right now with, let's say, chemotherapy. So I have to take 2 weeks now, but then I will use the other 6 or 8 weeks later on in the year. So also be aware that it doesn't necessarily need to be taken all at once. It can also be taken intermittently if requested and arranged directly with you as the employer. Again, DFA, or Department of Fair Employment and Housing, has now changed its name. So they are now CRA, or California Civil Rights Site. And here's the link down below that you can access for further information. Expanded crimes victims leave. I won't go into this too much. Again, I mentioned this is about domestic violence cases. So again, if there's any judicial proceedings, we never know what our employees are going through. And if they are open enough to disclose to you, this is what's happening with them personally, we will provide them with that ability to take a leave of absence or unpaid time off of work without any retaliation, because they have to take care of some domestic violence issues or court orders accordingly. And then to sum it all up, we've got mandatory 24 hours of paid sick leave, which is required if you were in a jurisdiction like San Jose that did require COVID paid sick leave for businesses of 26 or more. That has now ended as of last week. Vacation, there is no mandatory requirement for vacation. It is really up to you if you'd like to provide vacation time off to your employees. You can offer some kind of accrual system for vacation time where there's a maximum cap if not used every calendar year. And then leaves of absences, this is all that is required: FMLA, California pregnancy leave, disability leave, domestic abuse, bereavement, military service. I mentioned organ donor leave. That's something that's out there too in jury duty. These are all required leaves of absences, unpaid, and that if they do want to file for some kind of disability or pregnancy leave in the state of California, they go through the EDD for that. Okay. So what questions do we have on leaves of absences before I move on? Anything in the chat or anyone that would want to unmute themselves? All right, sick leave does not need to be paid out upon termination. Vacation and PTO is required to be paid out. Okay. So for businesses that have decided to implement a vacation and PTO policy, your sick leave is incorporated into that PTO. So yes, if your sick leave is incorporated into your paid time off, which is inclusive of vacation time, personal time, etc., that is required to get paid out by law because you've got your California sick leave included in your vacation and PTO payouts. So be aware of that. So vacation is not required by state law. California sick leave is required, but if you are offering a PTO program, your California sick leave is inclusive of your PTO. Can you pay an hourly employee for the 30-minute lunch period if they were interrupted for some reason? Yes, you can. But keep in mind, they are still offered a 30-minute unpaid meal period because of the interruption. Would like to waive that meal period, can they do that? If they are working a 7 to 8 hour shift and want to waive it with a signed mutual agreement ahead of time, yes, they can. But it is, again, not recommended because especially at the 7 and 8 hour mark, you start falling into some infringements there. So you definitely want to still give them that meal period. It's more like the 4, 5, and 6, which is the gray area, that you can waive that meal period and let them end their shift early with mutual agreement. 7 and 8 hour mark, no, I would not recommend you doing it because it's now the full shift. So the meal period of 30 minutes uninterrupted time should be provided. Sick leave. Okay, confused about sick leave. We do not pay it, only vacations. Well, it should legally, it should be the other way around. And again, we'd want to go specifically into how your vacation or PTO policy is written. But by legal requirements, it's only California sick leave that is required to get paid out. If you are offering vacation pay, then that does not necessarily need to be required to get paid out, but we would want to discuss that one-off on how your policy is written. The legal requirement by law for the state of California is sick leave. 30 hours a week for 120 days. If I have an employee who only works maybe 15 hours, do they earn the paid sick leave as well? Yes. And everyone who is an employee of yours earns paid sick leave. It's really a matter of, do you want to administer it on an accrual basis, or do you want to give them the full lump sum every year? The difference being the administration side of it and the tracking of it. Sometimes the people just want to do lump sum because it's less of a headache to have to track. Sick leave, again, does need to get paid out, and we can have one-off conversations on how you are setting this up for your business. Again, vacation, holiday pay is not a required paid offering. You are doing it probably because at the goodness of your heart and you want to give your employees the options for paid vacation time and paid holiday time. But it is not a legal requirement. The only legal requirement in the state of California is paid sick leave. Sick leave for exempt employees is the same. And which is probably why, if your population is more exempt versus non-exempt, it probably benefits you more to have a PTO or a vacation payout program. But again, it's all around strategy and semantics, and that's something we could discuss one-off if you need the one-off consultation. Okay, so I will move on and go through our last topic, hopefully of the day, with some additional information and any other questions that may come up. Workplace health and safety protocols. This is all around, oh, let me just make sure I'm sharing my screen. Can everyone see my screen? Yeah, it still says I'm sharing. Okay. Yes, great. Workplace compensation, injury and illness prevention plan, and other COVID protocols. So when COVID came out, November of 2022, many of you hopefully put together some kind of COVID and emergency temporary standards or a plan where you had your 6 feet apart stickers, you had hand sanitizer stations, you had the poster in the front of your window that had the big red check mark that stated that you are eligible and open for business. So all of that is no longer needed as a separate emergency temporary standards. This can now be inclusive of what we call the IIPP, or Injury and Illness Prevention Plan. We do not have to have anything any longer that is separate regarding COVID. You would want to have an Injury and Illness Prevention Plan, an IIPP. Okay, and this, you can get a really free and simple template on the dir.ca.gov site. So Department of Industrial Relations for the state of California site. It'll even tell you, I believe they have it separated out by industry. So by industry, what is going to be required for your particular industry in terms of an IIPP, or Injury and Illness and Prevention Plan. And the purpose of this is really just your commitment to safety and health overall within the workplace, right? This is inclusive of your workers' compensation plan. And again, we always think of a workers' comp plan really regularly when we think about construction-based businesses. I didn't see anybody in the chat coming from construction, engineering, trade businesses. Somebody gets hurt on the job while they're lifting the wood that needs to be brought into the house, or the HVAC system when they're crawling through your ceilings. All of that requires workers' compensation, right? But Every business obviously needs to have a workers' compensation program. Even, for example, that dance studio that I was talking about that didn't have one in place for their teachers and instructors that potentially get hurt on the job, right? So very important to have an IIP, which includes your workers' compensation insurance plan that you can offer to all your employees in any event that they get hurt on the job. There's objectives for accident and illness prevention in this plan. There's responsibilities for both your supervisors, managers, and employees on how to hold each other accountable for injury and illness in the workplace. There's procedures and processes in terms of communicating and investigating unsafe or unhealthy workplace conditions. So, for example, I mean, the simplest example, again, in a restaurant or retail service environment, what are the protocols when there's something that's spilled on the floor, or a slippery floor? You must have a process in place in order to put the sign, wipe it off, put the sign, that yellow sign up, etc., because you don't want anybody accidentally slipping on your floor, either employees or customers, because of the wet floor. So those are the processes that need to be documented and can be put into an injury and illness prevention plan, which you may already have somewhere. It's just not necessarily called this, right? Where's your fire extinguishers in the event in the back of the restaurant there's a fire on the stove, right? Where are they located? Where's the exit strategy for in the event of a fire in your workplace? All of this is all in your IIPP, and all the training that you're doing, especially in new hire training, you want it documented that they've completed the training, any instructions, and any record keeping to show that you've delivered this IIPP to all of your new hires. This also does need to be placed somewhere in a common area for review. So if it's just the binder, again, that you have in your work room, or break room, just like all your labor law posters, having an IIP binder will be key. And now that COVID has minimized a bit, you can list in there, COVID protocols. Here's what everything that they need to do at this point in time. What is considered someone who is exposed to COVID? So meaning you were exposed directly to someone in the workplace that has now been diagnosed with COVID. How do you document that in your binder to show this was the date that you were notified as the business owner, and here are the steps that you took to protect the other employees in the business, in the workplace, right? So if that person comes to you, an employee comes to you and says, I'm diagnosed with COVID, you've had them self-isolate or self-quarantine for 5 days or 10 days, depending on whether or not they had symptoms or not. So that is all documented in your IIPP binder. There have been requirements in Santa Clara County in the past to communicate a workplace exposure to the Department of Health of Santa Clara County. And again, workplace exposure in the past was 3 or more confirmed cases within a 2 to 3 week period. Okay, I think some of you may have seen the Costco notification that went out, things of that nature. Those needed to be reported to the County of Santa Clara. That is no longer required for 2023. However, what you may want to do is still notify your employees of potential outbreaks of 3 or more confirmed cases within a 2-week period of your workplace. So you can still provide notification to your employees of a potential outbreak, but it no longer needs to be reported to the County of Santa Clara. Okay. And if you have an outbreak and you do have employees that were in direct contact with that COVID employee that they have now have COVID, you are still responsible for ensuring that they get tested and potentially pay for time to test. So if you've got antigen tests are found, which are the take-home tests, those tests you see in the pharmacies, as long as you are providing that to your directly exposed employees to allow them to get tested, that is all that is required for you as an employer to legally have them do. If you are not providing them with the antigen test, then you are at least paying them for the time it'll take them to get tested or COVID tested at a local pharmacy or their doctor. So being aware, they again have to be directly exposed to the employee that has now reported to you that they have COVID. And direct exposure is now 15 minutes or more of time spent together in the similar workspace, and again within 12 feet or 12 inches or a feet or not, or 2 feet of space. Okay. These citations, if at any point you are cited for COVID exposure at your business or have not provided any notice of a COVID exposure, just be aware that if you get any of these from Cal OSHA, you do need to post this also in a commonplace area and must be posted in not just English, but the other languages that your workforce speak. But these are very few and far between at this point in time. However, just be aware it's still something that's out there in case you are cited for a workplace exposure outside of your company. Harassment prevention training. This is now going beyond the health and safety in the workplace, but still does involve comfort in the workplace, that all of your workers feel comfortable to be there. Harassment prevention training is required every 2 years for businesses, especially with 5 employees or more. 6 months of hire should be completed within that time, if possible. Training can be online or live. Some businesses elect to maybe have an annual live instructor come to their workplace and train all employees at once. That is certainly something you can do and pay for if you feel you want to. Manager does need 2 hours of training, and employees have an hour of training. And just keeping documentation and records of when these trainings have been completed is also important to have in your employee files. Now, there is a free training, online training, and it's self-paced and provided in several different languages. Again, if you visit the California Civil Rights Department, .ca.gov, there is a sexual harassment prevention training that you can complete free at no cost and at your own pace with like a nice little certificate that can be printed and posted at the end. So something for you to utilize and access at your own leisure. And then hiring minors. As we know, lately we've had a lot of labor force challenges, and so we've been hiring some high school students, right, to come work with us. Commonly in like service-based industries, retail services, whatnot. Please be mindful that you need to have a work permit on file signed by the school district and the student or employee's guardian or parent, allowing them to work, because we want to ensure that we don't get any infringements around child labor trafficking or human trafficking laws. And that children who work for their parents still need this. Obviously, the parent is already agreeing to it, but just making sure that it's also cleared by the school and you've got like a job description that you can provide to the school for the permit. Also, if you are an employer of minors, you are required to complete a mandated training. Okay, this mandated reporters training, I have the link there for the California Department of Social Services. It's a training that's being offered to ensure that you are aware if there's any child abuse situations going on and what to look for, and that you're mandated to report any child abuse observations that you are seeing within your workforce staff that are of minor age. Here's a sample of what that mandated reporting training looks like and what you need to have available and out there to support any minors that you have within your workforce. Okay. And then other employer responsibilities. We've got IRS mileage is going up. This again can be found on the IRS website for travel time. Again, if you are having to pay your employees for travel time, 62.5 cents per mile. 65.5 cents per mile now as of January 1st. So ensuring that reimbursement for mileage, if you are having your employees utilize their own cars to do anything that's work related. And again, I go back to traveling to the farmer's market, picking up inventory or ingredients, delivering packages or delivering food. That all requires mileage reimbursement to our employees, especially if they are using their own vehicles. So that's the 65.5 cents per mile. Agricultural workers has gone up. They have a lower threshold for overtime. It's going to be going up, but at another year or two, it'll just be the same all around for all workers. Emergency conditions. There have been some nuanced laws, very common sense laws around employer cannot take adverse action if, let's say there's an earthquake and an employee wants to leave the workplace because they need to go grab their children, grab their pets, grab their parents. We cannot, as employers, take adverse action against employees who are trying to leave work due to emergency conditions or flooding, for example, that has been happening earlier this year. If their home establishment has been flooded, you may want to allow them to leave work and get things established at home. Cannabis in the workplace. Now, they cannot come in and work impaired because, of course, cannabis and marijuana is legal in the state of California. However, you cannot discriminate or treat them any differently if they happen to have a cannabis habit or participate in cannabis outside of the workplace, right? So there shouldn't be any difference in treatment or retaliation or discrimination because they happen to have a practice in cannabis. But again, they cannot come into work impaired. But if it's something they do outside of work, there's no negative ramifications or any sort of difference of treatment for that employee because of it. Similar to the reproductive health and decision-making laws, we cannot retaliate against any employees that have, decided to take a leave due to their own reproductive health issues, right? Those are all decisions that they can make on their own, and we don't want to have any retaliation against them. And this is both cannabis and reproductive decision-making laws are state of California new laws that we're not retaliating or discriminating against anyone who has these types of decisions or personal preferences, if you will. There's a fast food council. I don't recall if anyone on the chat mentioned that they're from the fast food industry. This is very controversial right now and is still up in Sacramento, but this is about having a separate set of laws and a separate council that is overseeing the fast food industry and what the minimum wage requirements would be for them and what their meal and break rest periods will be for them. And this is predominantly targeting the larger organizations like the Chipotles and the McDonald's and whatnot. So being aware that is something that to keep an eye out on because there is still some works and nuances being handled there. Restroom access. This is a new law that we are obligated to allow anyone that comes in, especially with a medical condition or disability, to utilize our public restrooms. I know that a lot of times you'll see the sign, restrooms for customers only. This is regardless of them being a customer or not, especially if we obviously clearly see they've got a medical or disability condition. We want to allow them restroom access. And I mentioned earlier before, the retirement program is something that needs to be offered to all employees where they can start setting aside savings. You don't have to match. You just need to allow them an opportunity to set aside savings for their retirement. And right now it's a requirement of 5 employees or more, but I do anticipate in the next year or two, probably 2025, it'll just be regardless of how many employees you have, that you are offering some kind of retirement program for them. Again, you don't have to match. It's just giving them access to set aside savings for their retirement. And any final questions before we wrap? And I wanted to share with you again this resources page if you wanted to take a picture of it. These were all, again, those logos and those sites that I opened up this whole presentation with. And by all means, again, I did not go through every single nuanced law out there. It was mainly a lot of what I think is relevant to all of you as small business owners and all of you specifically in Santa Clara County. Yes, I can provide a hard copy of the slides to Crystal and she can send them out to all of the businesses out there. So for the sick leave option, what you're doing for one employee, you're doing for all, regardless of exempt or non-exempt. So once you've selected an option and you can, play with the numbers and whatnot and see, again, what your workforce looks like. Do you have predominantly part-timers? Will it make more sense that part-timers will be going through an accrual basis than you do? If you set yourself up with that's the way you're going to be administering California paid sick leave, you're going to do it for all, regardless of whether they are exempt or non-exempt. But more than likely your exempt employees get that California paid sick leave a lot faster than your non-exempt, right? We're under the assumption the exempt employees are working a lot more hours beyond the 40 hours a week. Back to sick leave. Yeah, less than 30 days in 1 year. They are employee, they qualify for sick leave. You have to accrue them that sick leave. So for every 30 hours work, they get 1 hour of sick leave, even if it's an hour. Yes, the second year restarts the clock, but you can continue to accrue it up to 48 hours.
So sorry, Michelle. I feel like I'm
sorry. That's okay.
So according from what I'm just was looking at the state of California, and so if an employee does not work 30 days in a year, they do not qualify for sick time.
They do not work 30 days in 1 year because
Correct.
they will not, because they do not accrue. How many hours do they work?
So I have people who work maybe just 2 days a month, for me 10 hours a month. I mean, it's very part-time. It's a winery, right? So it's fun. I get a lot of retirees who it's their happy place. But it's not at all a lot of hours. So
they are not accruing any sick time.
No, because they're working less than 30 days a year.
So if they're not accruing any sick time, you're fine.
Okay. So then, but my thought is okay, but what happens if I've had the same employee for multiple years? So now they've worked more than 30 days for us as an employer, but just not in 1 calendar year. Do you see what I'm saying?
Yeah. I would say I would recommend, because it's up to 48 hours that they can accrue. Even though you've had them year over year over year, I think at some point they would accrue some kind of sick time.
Assuming we're doing the accrual method.
Yes.
Correct. Got it.
Yes.
But you don't know for sure. You're just assuming.
I'm assuming. I'd have to look at the specifics of the employee.
Okay. That's awesome. Yeah. Thank you so much. I appreciate that.
No problem. Is CalSavers different from 401k retirement plan? It is. They have their own programs. When you go to the calsavers.gov site, they have their own programs. And so it is different. And when you're working in a corporation, you have a 401k or a 403, which is well, let me rephrase my answer to that question. They work similarly. All right. So technically they are different, but the way it works is similarly as a 401k plan. So it works similarly where when you're working in a corporate office, you have your 403c plan and you're getting deductions from your paycheck, every paycheck, to go towards that retirement plan. CalSavers works exactly the same way. Now, where they are investing the money for the retirement, it can be very different. So, and you get to choose with CalSavers as the employee where you want that money to be invested. Whereas in a 401k plan for a corporation or a company, sometimes the employee has no choice in where that money gets invested. It's whatever is being offered in that 401k plan, if that makes sense. Sick time is paid if they terminate both voluntarily or involuntary. If it's unused California paid sick time, it gets paid out both ways. Involuntarily, because you fired them, you're paying them out on the spot. Voluntarily, because they've decided to quit, you're paying them within 72 hours along with their final paycheck. And I go back to, if you are a business or a company that offers PTO, vacation time, holiday pay, we'd want to carefully take a look and see how that incorporates your California paid sick time. So reach out to me directly. I think Crystal earlier had provided you with my email address. .com. Okay. Oh, I will stop my screen sharing. All right. Any other questions?
Looks like there might be one more on there from Ginger.
Had to be provided. No. Retirement plans are legally required to be provided as of June of 2022 for businesses that have 5 employees or more. The match is not a requirement. So that is incorrect. It may be something that your program provider is telling you you need to do, depending on what program provider you are participating in it with. But for example, if you are with CalSavers, you do not need to match. The law just requires that you offer your employees a means of saving for retirement. Match is a nice to have. That's great as an employer. If you're matching, that's a great retention strategy as well. Just like as an employer, if you're offering vacation time and personal leave time, that is a great perk to have as an employer. But for the legal requirements of it, it is not required to match or provide vacation time. Yes, I believe the employees do need to be 18 years or older. That is correct. But I will double check on that as well, because yeah, we're talking about, yes, 5 or more employees above the age of 18. So I will double check on that. But yes, I believe they have to be 18 years or older. Although below 18 doesn't hurt to start planning for retirement as well. Like, you know. Okay, so if you, go ahead, Crystal.
Oh, go ahead.
Yeah, so if there's no other questions, again, my name is Melissa Sanchez. You can find me on my email, melissa@melissasanchezcoaching.com, or the Access SBDC.org website. So be aware that I am an SBDC advisor, which stands for Small Business Development Center. And then if there's anything else, Crystal can obviously find a way to connect us as well if push comes to shove. But thank you again, everyone, for today's presentation. And I hope I was able to share enough information for all of you to feel confident going forward.
So everyone, I will be sending out the slides as soon as I get them from Melissa to you. And once I have that done, I will also include any information I can about her, so you can contact her directly if need be. And if you have any questions for me, just reach out, crystalc@sjchamber.com. And I hope to see you at the next one. Have a good evening.
Thank you.